Good afternoon, everyone. Welcome to our webinar. This is the first in a series we hope to be running over the next few weeks and months, talking on some of the hot topics that DPOs in organisations around the globe probably thinking about. Today, we're actually looking at the global impact of the GDPR and how that affects businesses, whether in the EU or actually in other parts of the world, and also the knock-on effect that the GDPR has had on other regulations throughout the globe. I'm joined today by TASH WHITAKER. TASH joins us as a specialist in the area of data privacy. She's got over 20 years of experience of implementing governance solutions, managing data in organisations like Dun & Bradstreet, Cisco, and also working with Moorcrofts, the law firm. Tash now works as an independent consultant, and she uses her knowledge and experience of implementing these kind of processes and solutions to organisations all around the world. And that consultancy includes general advice, taking through their data privacy journey, and also training, and also actually outsourcing some of the DPO processes. Just wanted to also give you a brief introduction to myself. My name is David Silsby. I act as the Regional Sales Manager for Rangu. And just the one slide, which is the blatant sales pitch, and then we'll get on to the brief matter, but introducing who we are, because some of you may not know us. We are a specialist provider of GRC, security operations and data privacy solutions. In particular, we work with a technology platform based on the ServiceNow platform, but we have a number of subject matter experts in all of these areas. And one of our key solutions is our GDPR Accelerator solution, which is specifically designed to help DPOs manage and automate some of the processes that they probably struggled with and perhaps doing manually at the moment. So things like DPIA, ROPA, the subject access requests, and also the data breach management and reporting in terms of regulatory requirements. So we've implemented these solutions in organizations of all sizes throughout the world, and as such, we've become, I guess, somewhat subject matter experts in this area as well. So I think without further ado, it's probably worth just getting into the meat of the subject today. And as I said, we're talking about the global impact of the GDPR. So let me start by asking Tash, what has been the global impact?
Hi, David. Thanks for having me here. Well, it's an interesting question. Before I start, I am going to say that anything I say isn't legal advice or anything like that, so please don't sue me. It's just going to be a discussion between you and me on some of the impacts that we've seen. So we know that the GDPR itself covers any business based in the EU and then any business outside the EU that is offering products and services to EU data subjects. When GDPR first came out, there was a lot of talk around the fact that it's supposed to be extraterritorial, and that's actually really, really hard to implement. And a lot of people said, "Oh, that we won't be able to do this. It's just going to be EU only, and it's not going to impact the rest of the world because there's nothing you can do about it." And actually, we've seen that's not the case. We've seen that there are data protection authorities who have started enforcement action outside the EU. We had the ICO in the UK, for example, who did enforcement action against Aggregate IQ, which was a Canadian company involved in the Cambridge Analytica scandal, where they didn't put a monetary sanction against them, but they did say that that company is no longer allowed to process the data of UK data subjects. So we've seen that happen. I mean, admittedly, that company had actually already closed down, so it was, not worth very much at all. But the intention was there. We've also seen that CNIL, that's the French data protection authority, has fined Google 50 million euros due to lack of transparency in the work that they're doing. So we have seen that there is extraterritorial work happening as a result of GDPR itself. But where we've seen really I would say some of the much wider ripple effects going down is where other countries have made changes to their own laws and their own practices as a result of GDPR. So there have been some spin-off laws that have happened, things like we've got the ICO has just announced the UK appropriate sign code. We've got some of the laws in the US, copper, having been changed now, and that is partially attributable to GDPR. But what we see in the most part is that because data subjects now understand their rights more, they realise that their data is being exploited, that these big companies are basically using sort of their secondary shadow self and making money out of it. They're protesting more, and countries are having to react. So we've seen things like the new CCPA in the USA. We've got other state laws and bills coming in the USA. Japan, we've seen them change for adequacy. Brazil has a new data protection law coming in. Canada are proposing changes. So really, across the world, what we've seen is this rising tide caused by GDPR is basically raising all the boats in the ocean.
Okay, so thanks for that, Tash. Before I've got a question to ask you. But I forgot to mention that the housekeeping at the beginning of this. So we do want to field questions during this webinar, and we'll have a section to answer those at the end. If anyone has a question, we've actually muted you all for the sake of sanity during this broadcast. But if you could type your questions in the chat box, and we'll come to those if we get an opportunity at the end. Okay, so Tash, tell me a bit more about the privacy and data protection in the USA.
Sure. So the one that most people are familiar with is the new CCPA, the Californian law that is coming in. It's due to come into force in January of next year. But the interesting thing is that some of the regulations in there talk about data that was collected within the last 12 months. So there's work that people are going to have to be doing now to make sure that they're prepared for when the CCPA comes into force. Overall, the CCPA applies to businesses who collect and sell personal information about consumers who are Californian residents. Now, because of the size of the Californian sort of economy, for want of a better way of saying it, this really is going to have global reach because there are so many entities that are using data on Californian residents. So it's not just going to be businesses that are based in California, it is going to be anyone that is buying, selling, collecting information about California residents. So what we're seeing here is actually a lot of companies in the US, they're putting CCPA in place, but what they're doing is just making it eligible to everybody or applicable to everybody. You know, that is becoming their standard. There are quite a few differences between that and the GDPR. So if we look at the do not sell, there needs to be on all websites the ability for a consumer to say, I don't want you to sell my data. Now, saying that, there's nothing to say, don't share it. And that is something which there are various bills coming in. So there's a bill going through at the moment, which is the Privacy for All Act of 2019, where they want to make this even stricter and say, don't just say do not sell, but also allow us to opt out of you sharing it as well. There's also lots of exceptions under the CCPA. So things like de-identified data, health data, clinical trial data. Health data, clinical trial data come under a different set of legislations. But de-identified data is interesting because the definition of de-identified data in the US is not as clear as it is under the GDPR. Now, under the GDPR, we would say that anonymous data isn't included. But to truly anonymize something is very, very difficult under the GDPR. You have to make sure that absolutely nobody can re-identify it. Whereas in the US, they tend to think of de-identified data as we took your name off. You know, there was a really good example here where there was a bill going through where a particular senator wanted all health data to be de-identified and shared with medical companies. And what a privacy researcher did is he managed to get hold of this data and using the data that would have been made available to these companies, so just having the name off, he was able to work out which of these medical records belong to that senator just by looking at the postcode, the gender, and the age. And so he'd put it in the post and sent it to him, and that immediately just stopped that bill. They decide there and then that's not de-identified. So we do have to be quite careful with the US definitions of de-identified, because it's probably not as strict as the GDPR one, but it's a step in the right direction at least. There is still a right of access, but only for data that's been collected in the last 12 months. So not quite as large as the GDPR one. And there is no right to Asia. So again, it's close and it covers quite a big proportion of the US in terms of their economy, but it's not really enough. There are other bills out there, the Wyden Act, people are calling it, which is the Consumer Data Protection Act, that's going through Congress at the moment, which is very, very similar to the GDPR and would cover the whole of the US if it goes through. Whether it will or not, we don't know. It's likely that there will be something that's put through and it'll get watered down. But I truly believe that had it not been for GDPR, we wouldn't be seeing this happening now.
Okay. And do you think that other states are waiting for the Congress decision before bringing in their own privacy regulations and then stick to sort of the central federal requirements?
Probably not, because we are seeing individual states having their own laws anyway, and there are some which are stricter than others. I think a little bit like when you think back to when we were with the Data Protection Act of 1998, back then, where everybody in Europe had their own data protection laws and they were a little bit mismatched, and GDPR really was the one that harmonised everything because that was its aim. I think the US is probably in a situation where they're going to have almost sort of an unfair competition situation where the different states have different laws. Some are going to be better than others. And they are going to need this thing, federal one, right across to make sure they have harmony across the US. But I think that'll be a little while yet. Okay,
great. So the next question I have, it's to do with self-esteem, I think. But I just wanted to ask about, there's a lot of talk about adequacy. Can you tell me a little bit about that?
Yeah, okay. So what adequacy is, it's a part of the GDPR which says that essentially you cannot transfer personal data outside the EEA unless a set of criteria apply. And it's very, very clear, it's prohibited unless these criteria apply. And one of those criteria is the concept of adequacy, which says that the EU is happy that a certain country or a set of entities within a country or even an industry is going to treat your data the same way that GDPR expects to be treated or better. Now, you've got a couple of examples of this where particular countries will have adequacy. And then you have situations like in the US where certain companies have adequacy under the Privacy Shield, which is a self-sign-up thing. And under PIPEDA in Canada, we can transfer data to Canada under that sort of regulations. Or rather under that protection is probably a better way of saying it. Now, in order for a country to be adequate, it obviously has to have really good data protection laws. And Japan put through their request for adequacy, I think just before GDPR came into force, maybe a bit before that, because it's taken quite a long time for it to go through. And what we've ended up with is a situation where we can now transfer data to Japan. They can transfer data back to us, no problem at all, under this adequacy agreement. But they've now got a two-tier system as a result, which I'm hoping that GDPR will change and help them harmonise. And what's happened is that data about EU data subjects is held to a slightly higher level of protection than their own. So things like special category data. So under the GDPR, we have a set of types of data which are special category. We must therefore look after them better. We have to have a second reason for processing them and so on. In Japan, they don't consider to be for information on trade unionship, your sex life or sexual orientation to be special category. So what they've had to do is put an extra level in that says, unless you are an EU data subject, in which case they are, and we will look after them better. Japanese citizens have no right to access data if the plan is that the entity will delete it within 6 months. However, EU data subjects do have that right in Japan. So what we've ended up with is, in some situations, companies in Japan have to this two-tier effect. And again, what's ended up happening is they're saying, you know what, if we've got to put this in place for one set of people, we'll put it in place for everyone. So although the law isn't changing, the behaviour in the companies is changing quite a lot to make sure that there's a level of parity, and that is like a gold standard, lowest common denominator, essentially.
Okay. So what about other countries?
So we've got a few here that you can look at. You've got Brazil, who has got a new data protection law coming out. Just see if I can switch slides. That's coming out in 2020. It's still a little bit up in the air. One of the interesting things that they've included, though, is anonymous data is in scope if there is a way to use it for discriminatory purposes. And I find that really interesting because that's gone one step beyond GDPR. Likewise, they're saying you absolutely have to have a data protection officer. So and their subject access request is a 15-day instead of a 30-day limit.
Right.
So there's actually, they've got some steps further than the GDPR has, but everything else is pretty much based on the GDPR. You know, we're even seeing countries like Russia and China bringing in some laws. You know, again, they're very interesting the way they're doing it. If we look at Russia, for example, they have a law that if you're going to be processing data about Russian citizens, then that data must stay in Russia. And they've actually banned LinkedIn from Russia now because they weren't adhering to that. And they fined Facebook, was in the news yesterday, the grand total of £37 for not storing the data in Russia. But interestingly, that's basically something they had to do in order to move up the legal chain as a first step towards banning them in Russia. So it's actually quite significant. It's a tiny, tiny fine, but it is significant. You know, I guess there are questions raised about, hold on, but I thought Russia quite liked using Facebook for various reasons. You know, what's going to happen if they do get rid of it in Russia? I don't know. China as well has brought in some data protection laws as well as some security laws around the data. Again, focus very much on making sure the data stays within their own country and isn't exported out. But at the same time, they are using a lot of special category data on their own Muslim minorities. So there's been some movement in countries like that, you know, but it's tiny, tiny baby steps. But it is at least a step in the right direction. People's expectations are much higher now than they were previously. They really expect data to be looked after. They're more aware of it. And that's something we never saw before.
Okay, so it sounds like, you know, that ripple effect is starting to accelerate as more people become aware of the requirement. What about the effect on businesses? What's been their reaction, the people who hold the data?
Yeah, so this has been interesting. So when GDPR first came out, most companies like, oh my God, I can't do this. Or your company saying, well, I'm not going to do it. Other ones saying, well, we do it already, when actually they weren't doing it already. And it was seen very much as a barrier to business. And if they were doing anything, it was always as a one-off project. What we're seeing now is a complete mindset change when companies are beginning to see that actually it's really, really good for business. And I feel a little bit to some extent that some companies are, you know, really playing it. You could argue that Apple, with their whole, you know, what happens on your iPhone stays on your iPhone, your privacy matters. They are getting much better at privacy, and they are using it as a unique selling point to their product. And in a way, that's good, because one of the things that as a professional I've really struggled with is trying to get people to understand that data protection isn't there to stop your business. It's there to help harmonise the regulations to ensure that you can transfer data where it needs to go safely and that people will trust you. And that trust is really, really important, because that's what enables you to grow your business. So it's an enabler to business. It's not something that's trying to stop you. So I'm quite grateful for the way that Apple have done this, you know, really jumped on that bandwagon. But we've also seen more than just this. We've actually seen sort of much lower in the works. We've seen that there are situations where the GDPR has made a really big difference to companies that wouldn't have changed otherwise. So if we look at, for example, the Dutch Ministry of Security and Justice last year, they asked a company to do a data protection impact assessment on Microsoft, on, I think it was Microsoft Office Pro Plus. And that, normally when you're doing a data privacy impact assessment, you tend to think it's something that your company does for you to see what the impact is of carrying out a particular project. Now, by someone like the government doing something this high profile and then releasing the results of it, this wasn't the DPA stepping in and saying, Microsoft, you've got a problem. This was instead this information going out there going, guys, you can't trust what Microsoft are doing because look, this is the impact of using their software. And what they found was it violated data protection laws in terms of transparency, purpose limitation. They didn't have legal grounds for processing some of the data that they were holding. So there were all these things, and they actually advised, in an ideal world, you shouldn't be using SharePoint, you shouldn't be using OneDrive, you shouldn't be using the online 365. And, and it was a real eye-opener to see this being published and put out there. And then they just sort of sat back and waited for Microsoft to respond, which I thought was a really, really good way of doing it, because they weren't saying we're going to sanction you. We're like, look, we're telling everyone what you're doing. And literally within days, Microsoft came back and said, okay, we're changing this, we're changing this, we're changing this, we're changing this, and we're rolling it all out. Not only that, but we're not just doing it for EU data subjects, we're going to do it for everybody now. And so there's ways and means that the GDPR has rippled things out without having to talk about these 4% fines and these 2% fines, things that were really the headlines. Going back sort of May time when everyone was getting scared. There's other ways of doing it and other behaviour changes that have happened as a result of it.
Okay, wow. That's really interesting. So it sounds that myself as an individual, that the knock-on effect is actually it's having a much more respect for my data and recognizing that, and that big business is starting to take notice of that.
Yeah, the other thing which I noticed, and if I do a presentation, I often share slides on this, but I haven't got them here, is if you look at, if you've ever done a Google search trend search, where you can actually look up to see how many people have been searching for various things over time, and you put a search request in for GDPR, what you see is a trajectory going right up to the 25th of May and then dropping right down. And I think a lot of people have said, see, told you GDPR was just a Y2K thing, it was never going to last. If you then do another search on data breach compensation, what you see is where GDPR starts to drop down, the people searching for compensation goes up. And that's partly because one of the new things within GDPR was it allows the right to class action. So you can be compensated if you can prove distress as a result of a data breach. And so we've still got as many people interested in GDPR, but for a different reason. Initially, it was how do I comply with GDPR? And now it's what's in it for me, and what's the impact on me as a data subject of GDPR? I suddenly have these new rights and I have more control, and I want to hold people accountable for it. So for a business, I'd say it's a little bit more dangerous that the consumers know so much, and it's a really good thing. I'm glad they do. And off the back of that, we've seen that the BA data breach, there are companies now trying to put class action together on that. There's a class action just started as a result of the Ticketmaster breach. And then if we go over to the US, they've just had the largest ever privacy class action. It went to jury trial, which is really unusual. And it's based on 800,000 people, I think it was, who were receiving robot phone calls. And the payout is $925 million. So it's the largest ever privacy class action.
Wow.
So I can see that starting to build up. I'm not saying it's going to be huge, because the proof of the pudding over here in the EU is going to be, can you prove distress? The US are pretty good at proving distress. I think we as a continent are a lot more reserved and, a bit more like, seriously, is that really distress, or are you just trying to get money out of us? So I think when the first class action goes through, that's either going to tap them all right down and everyone's going to say, that doesn't happen, it's not worth doing, or it's going to open the floodgates. So we're going to wait and see what comes of those.
Okay. So it's interesting you raised about that trend, ramping up till May last year. I think, most of us were probably getting sick of hearing about, getting the emails about our privacy policy has been updated and having to accept all of those.
Mm-hmm.
Something else I think we're getting sick of hearing about now, but I'm going to ask you a question about it, is what about Brexit? Hasn't happened yet, but is there an impact? Can we expect any knock-on effects from that?
Yeah, I'm quite proud of myself actually, because a lot of my clients said to me, what about Brexit? Do we need to do this? Do we need to start doing this? And I kept saying, don't do anything before the March deadline, because I think we're going to be okay for a bit longer. So luckily, no one's actually spent anything. None of my clients have yet, but they are prepared to. The things that we need to be looking at is if we end up going out of Brexit with no deal, we become one of those countries that doesn't have adequacy. So that means that the EU or the EEA cannot transfer data to us immediately. They have to put certain things in place to be allowed to do that. The most obvious ones of these would be the contractual clauses, the EU contractual clauses. But that means that you've got to have a really good look at your record of processing and say, okay, so where in my record of processing am I transferring data out to the EU, which is still going to be allowed, but where is data being transferred into me? Because there we're going to have to look at what contractual clauses we might have to put in place. Even if it's just transferring it between your head office and a location in the UK, we are going to have some mechanism in place for adequacy there. Now, we could say, oh yeah, but we've got adequacy now because we're part of the EU, so when we leave, it should be really easy for us to get adequacy. I would say, no, it's not. It took Japan nearly 2 years to do it. I think at the moment, if I look at the situation that the UK is in and some of the laws that they have and the way the government works, if we were not part of the EU now, we wouldn't have adequacy. And that is just my personal opinion. So I think there is a lot that would have to be done to get us to the standard for adequacy if we leave the EU, when we leave the EU. So we have to be prepared for the fact it's not going to be an immediate, we can just carry on as we are. We are going to have to put things in place. The other thing to think about is going to be EU representatives. So at the moment, if you deal with information on data subjects within the EU, but you don't have a location in the EU, you have to have an EU representative office in the EU where some of those data subjects are based. Now, as soon as we leave the EU, we're likely to be in that situation. There are going to be many, many businesses in the UK who don't have a location in Europe, but they are dealing with data subjects in Europe. So that means they're going to have to appoint an EU representative. At the moment, everyone's a little bit up in the air about that. I've only seen 2 companies in the UK offering this service that, look like they know what they're doing. I think everyone else is just holding off on waiting and seeing. No one's going to do it on day one as soon as we leave, but it's something we are all going to have to do. So that's going to be potentially an extra cost to businesses, because in most cases, that's going to be an outsourced service of a consultancy, a law firm, or something else. The final thing we have to be aware of is we will have the the UK GDPR when we leave. So it's being rewritten for the UK. So we will have to abide by that when we're dealing with UK data subjects. When we are dealing with EU data subjects, we will have to deal with the EU GDPR. So potentially 2 different sets of regulations. Now, the other part of that means that if something goes wrong and we're dealing with European data subjects, the ICO can fine us, but the entity, the DPA in the EU of that country can also fine us. Now, if you have an issue and you're dealing with multiple EU countries, we will now no longer be part of the one-stop shop thing. So in theory, we could be fined by the ICO. We could also be fined by every DPA where we have impacted data subjects in Europe. So that's quite significant. I'm really hoping that somehow the UK government is going to find a way to work through that, because, one data breach could end up costing a lot more once we're out of Europe than when we were in Europe. So it's something we have to bear in mind. So what I would say is to everyone, make sure your record of processing is up to date and you know exactly which bits of your data are going where and where your data is coming from as well.
Okay, brilliant. Thank you. We've actually had a question come in, and that probably leads us on nicely to the next slide anyway. We were coming up to wrapping up and having a question and answer session. So the question, I think you've kind of covered this already, but maybe put a little bit more detail around it, is what sort of things do you have to be put in place for adequacy, in your opinion?
Yeah, so this is going to have to be my opinion. It's not something I've gone direct into, but I know that there are certain things that we do where, for example, we don't allow asylum seekers to have access to some information that we allow other people to have access to in the UK, which would not, if we were out of the EU now, would not give us adequacy. Does that make sense? So there's things that the government is doing and how they decide what can and cannot be shown to people in terms of transparency, access to their own data, that would not be considered adequate. So yes, that's one of the areas. I suspect that when the EU come to test us, there will be a lot more, because I suspect there are things that we say we do that when they actually look at us, we're not really doing. I think someone was mentioning earlier on today that even the ICO, for example, their website is not really compliant with GDPR yet. I know that the ICO hasn't yet provided fair processing notices to its employees, which everyone else was doing back in May last year. So there are things which have put us slightly behind, which I think the EU would have every right to turn around and say, until these things are right, you are not having adequacy.
So is that the government, the UK government, the ICO's responsibility, or for individual businesses?
I think at the moment we can only control what we can control. So it's going to be individual businesses making sure they're doing the right thing. You know, I always say it doesn't matter whether you're looking at GDPR, Data Protection Act 2018, UK GDPR, it still comes down to our ethical compass. You have to do the right thing. If you think you need to hide what you're doing with your data, if you're not telling people what you're doing with your data, you probably shouldn't be doing it. So if everyone works to sort of that thing and do the right thing, we're all going to be on the way there. But then there is going to be stuff which we have no control over. The UK government is going to have to deal with, is going to have to do a better job on, and they're going to have to work to it. What we have heard, which worries me slightly, is that when the UK leaves the EU and we are starting to decide who we consider to be adequate to pass data to, it won't actually be the ICO that has to approve it anymore. It will be, I think it's the Secretary of State. Now, again, personal view, that really worries me, because that means that there is nothing stopping a member of the government talking to the US, for example, and exchanging adequacy for chlorinated chicken. So it could become something that is used in trade deals. And that's not what data protection is about. So that worries me a lot. So there are still lots of unanswered questions, lots of things we don't know exactly what's going to happen. But in terms of what businesses can do to prepare themselves for a no-deal Brexit, it's going to be mainly about those transfers and the EU representation.
Okay. So another question we've had, you mentioned about, if Brexit actually does happen, that we'd have to have a registered office in the EU to handle the DPO kind of matters. So could a UK DPO continue to operate from the UK if they set up an office in the EU?
So if you appoint a registered office in the EU, that's actually separate from the DPO work. DPO is much, much bigger than just the representative office. So I'm going to answer those two questions separately. So yes, the UK DPO can continue to operate from the UK. The representative office, not registered, sorry, the representative office would be based wherever your data subjects are. Now, if you are an entity that needs a DPO, then your data subjects have to be easily be able to get hold of your DPO. So there is a question at the moment as to whether a UK-based DPO is enough. It might be that if the EU GDPR says you need a DPO, you might have to have it in Europe so that your data subjects got better access to it. So again, questions that haven't quite been hammered out yet, but at the moment we're saying yes, a UK DPO can continue to be a UK and EU DPO as long as the data subjects have access to that DPO.
Okay. For the time being.
Yeah. Until we've got otherwise.
Sure. Okay. So, and then Chris has asked another question. So this is, would maintaining a ROPA cover the obligation to have a DPIA for certain processing activities?
No, they're two completely separate things. So your record of processing is basically a working document that says what data do you hold, what's your lawful basis for holding it, what are you doing with it, where are you storing it, where did it come from, what are you doing to secure that data, who do you transfer it to? So it's basically a reference document for all the data that you hold. A data protection impact assessment is looking at any new project that you do, or even any old projects that you have done that might have some form of risk to the data subject. And there's a lot of criteria you have to look at to see whether or not something needs a data protection impact assessment. But essentially what that is doing is looking at the new project and saying, what are the risks to the data subject? Let's talk to the data subject, let's talk to the DPO, let's talk to experts in this field and see how we can mitigate those risks. And only once we've mitigated them down to the risk level that we're happy with, will we give sign off for this project to happen.
Okay, great. So very briefly, just skipping back to the previous topic about the offices in the EU. The question is, do you need a representative office in each country where you process the personal data, or just in one EU country is sufficient?
Just in one EU country. The only stipulation needs to be that some of the data subjects need to be there. I fully suspect that there will be changes to that, where they'll say a majority of your data subjects, you know, when you're looking for which country to put it in. But at the moment, it just says some. It keeps changing. The ICO keep changing their guidance. So depending what day you look at the website, it either says some or it says majority. At the moment, as of today, it says some. But no, it would only be one representative office in Europe. Yeah,
and I guess that can change with any business, right? One year they could have a majority in one country, and
exactly. And I'm hoping that's why they changed it to some, because majority just made no sense.
Okay, great. One other question I have: you spoke about the impact on businesses. Do you think that there's been an impact on private, individuals, the data subjects themselves, since the launch of GDPR? Is it making their lives better, worse?
I think it's making them more aware. I think on the lead up to the 25th of May, all we got was these stupid, in many cases unlawful emails saying, we need your consent, we need your consent, and everyone was sick to death of it. I think once GDPR started to settle in and everyone in their day-to-day work as a consumer could stop hearing about it and just it became a way of life. Now, as data subjects, we're more aware of what people are doing. We're hearing about breaches. These breaches were already happening. Just previously, we didn't know about it. So we're much more aware of it, and we're more aware of what people are doing with our data. So when we hear that Emma's Diary, for example, has been fined a certain amount of money for selling data of pregnant women, we now get the bigger picture. We now realise that the reason that was such a problem is that they were collecting information on pregnant women. When people are pregnant, they are considered more vulnerable because they're more likely to change the way they do things. So they're more likely to consider that they might be buying a new car. They might want to move house. They might want to change their political allegiance because they're thinking, I'm bringing a new person into the world. Should I really be voting Labour or should I be voting for the Green Party? So marketers know that's when people are most vulnerable to change. So that data on pregnant women is really, really valuable. So when Emma's Diary took that data and they sold it to Experian, and Experian sold it to the Labour Party, suddenly we now have all those dots connected that we would never party to before. Yeah. Before, people would say, well, what's it matter? Who cares? Now we have the full story, we see the impact, and we start to think, hold on, that's not right. And because that's how we feel, people are starting to vote with their feet. on the companies that they use. They go in and they say, I don't want you to track me. I don't want you to do this. I want to regain control of my own self. And that's what I think is happening to data subjects.
Brilliant. Okay, thanks very much, Tash. Is there anything you'd like to say just to wrap up before we kind of close this off?
No, I think that's it. We've only got 2 minutes left, so I think that's it, unless anyone's got any more questions.
Okay, brilliant. So I want to thank everyone for joining us today. We hope it's been useful. Thanks especially, Tash, for your expertise and knowledge in the area. So you can see our contact details up there on the screen. We'd really like you to reach out to us if you have any further questions. By all means, send us an email to myself or Tash. One thing to really I want to plug right now, but let you know, we have our next webinar coming up on May the 2nd at 2 p.m. UK time, and that's an Ask the DPO session. Tash will be joining us for that as well, and we'll be talking about some of the latest regulations coming on, changes in laws, etc., privacy laws, but also we'll open up a time where you can email in questions beforehand or ask them on the fly, and we'll answering, you know, some of the, hopefully answering some of the questions around the big issues that DPOs are facing today. So you can email if you want to register, evan@rangu.com, or also by copying the link, the bit.ly link, and you can register for that there. So thanks for everyone for joining us today. We hope you enjoyed it, and hopefully we'll see you again. Take care.